The second myth is you need to leave your home immediately. That's not the case. Typically when you get that foreclosure complaint, that is the initial stages of the foreclosure process. Like I said, there will be at least a window of 20 days in which you have to respond. Now, I practice in both Lee and Collier County, and I know the courts have actually started assigning particular judges or magistrates to hear the majority of the foreclosures. And I know in particular in Lee County, there's actually a senior judge that hears all of the cases where the defendants have failed to file a response. Those cases have actually been defaulted. Those defendants have been defaulted, and in those particular cases, they're getting hearing time, I would say, relatively quickly within the 1 to 3 month range. That's a very short range, and I would say that your typical foreclosure process goes well beyond that. It can take upwards of a year, to be honest with you. It ultimately depends on the aggressiveness of the law firm that is handling those particular cases. And I guarantee you, I've been in the courts and I've seen, there's firms that are handling thousands of these things, and they don't necessarily have the time to aggressively pursue them as much as they want to because of the volume that they actually have. That is a huge myth, and don't panic when you get served with a foreclosure complaint as a tenant. Do what I earlier recommended, which is file an answer, get something in the court file of record on your behalf, allowing you to at least get served with notice of what else is going to happen in that case. And I think if you take those proactive actions, you will be in a far better place than you would be if you had not. I think the key here is to be proactive, and I think all of you, by simply being here, are being proactive. The other issue that I briefly want to talk about, and it's also an issue that kind of gets lost in the foreclosure process, is that a lot of people tend to focus on the banks as being the plaintiffs in most of their cases. Well, that's a misconception as well, because oftentimes the homeowners associations and the condominium associations are also bringing these actions. Like I mentioned earlier, they have a duty to their members to collect assessments, and most boards are not going to allow assessments to go unpaid for too long, especially in this day and age. One, because of their obligation to their association and their members, but two, because they don't want to subject themselves to a possible selective enforcement argument by a unit owner who says, hey, you took 3 days to foreclose on me, but you never even once tried to foreclose on my neighbor down the street. So oftentimes homeowners associations tend to be more aggressive in those particular situations. Another reason that an issue that affects those who are being foreclosed by a homeowners association or a condominium association is that in those particular cases, by failing to pay your assessments, oftentimes your governing docs permit for restrictions of the use of facilities, for instance. So by failing to pay your assessments, you may be restricted from using the pool, the gym, or other facilities that may be on the association premises. Another issue that may be affecting those who are having actions brought against them by the homeowners association or the condominium associations are for failure to upkeep the property. And I believe this was mentioned by several of the panelists with respect to whether or not the failure to maintain your property. In some circumstances, governing docs permit for a lien to be attached to the property. The association can, upon notice, come in and make the appropriate repairs and then charge them back against the particular unit owner. Oftentimes, and I've seen this in the past, associations tend to bring actions, whether they be in the case of a condominium association, what is called a petition for arbitration with the state for violation of a condominium restriction, which may be a failure to maintain your property. In these instances, a petition for arbitration is governed by state processing and generally can be a more expedited process than your simple foreclosure action. And oftentimes I've found that associations may opt to bring that course of action because of the shortened time period in which they may resolve it. Typically, they have you immediately go into a mediation process, and in some cases, the issue is resolved. If not, it later goes to an arbitrator for a decision. Pretty much, these are the brief issues that I wanted to touch upon. I just wanted to kind of make the group aware that there are other issues that affect the foreclosure process other than just homeowners. There are tenants out there, and there are other plaintiffs other than just banks. Those would be your homeowners association and condominium associations.